Alex here with part 85 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Now we move on to a renewed motion. I'm trying to wonder why I handled it this way because if I remember correctly, the judge never struck my motion to reduce my ex's child support arrearages to a judgment. He just struck the request for submission. So one of two things must have happened. The first thing might be that my ex's attorney just never responded to it, and just to play it safe, I filed a renewed motion. The second, which is more likely, is that I think that upon reading the judge's order striking, he may have raised certain things in that order that I wanted to address, and the only way to possibly do that, at least according to what I thought back then, was to just file a renewed motion that contained new assertions dealing with some of those things that the judge raised. One of them that comes to mind is the superfluous point. I guess he says it's superfluous to ask for a judgment, which I probably addressed. I haven't looked at this ahead of time, so I don't know. And then the second thing that he raised had to do with me getting help from an attorney or from a self-help center. And so I may have addressed that issue. It's kind of fun trying to figure out what I was thinking 9 or 10 years ago. And so I may be completely wrong. We're going to go ahead actually at this point right now and take a look at what I have filed. Here we have the renewed motion for judgment on child support arrearages. The first thing I want to mention, guys, is I'm going to be skipping over the portions of this motion that are identical to the motion that we went over in part 83 of the My Docket series. Typically, a renewed motion is copy-paste with a few things, sometimes nothing actually, sometimes nothing's been changed or added. But typically, if anything has been added, it's very little. So let's go ahead and so introductory paragraph, I guess I'll mention this because it's pretty important to have in any motion, but this is the portion that introduces myself to the court as the petitioner and indicates that I am unrepresented by stating that I'm appearing in proper person. And we have the same factual background. Okay, so here's one of the changes. Right down here at the bottom of page 2, I'm asserting that the court entered an order striking my request for submission. Here's a footnote. In striking only the request, the court allowed the original application to survive. Okay, yeah. I mean, I don't know why I needed to file this then, but I am pointing out that the court is asserting that my request was superfluous, and I'm denying that. So let's see here. Argument. So I'm seeing it looks like this is the same assertion as, nope, this is new. Okay, so this is new here. The next paragraph here following the statute, which I did cite in that previous motion, is that this statute appears to support the judge's position that asking for a judgment is superfluous, but the judge fails to consider the fact that district court clerks will reject any attempt to enter an execution without a corresponding judgment. Subsection 3, or footnote number 3. I'm going to check this really quickly. NRS 21.020 in footnote 3, the writ of execution must be issued in the name of the state of Nevada, sealed with the seal of the court, and subscribed by the clerk, and must be directed to the sheriff. Oh, here's in bold, and must intelligibly refer to the judgment, stating the court, the county where the judgment roll is filed, and names of the parties, the judgment, and if it is for money. So that's me pointing out that he's wrong about that. Furthermore, reducing child support to a judgment is not without precedent, and I think I found two cases. Here's one, Westgate v. Westgate. I remember in Part 83 wanting to discuss this. It looks like this is a citation I was looking for. We note, however, that Murray's child support must be reduced to a judgment. Let's see what the Supreme Court is stating. When either party to an action for divorce makes default in paying any sum of money as required, the court may make an order directing entry of judgment for the amount of... Okay, so this is what I was talking about. This is the discretionary language that concerned me at the time. It says that the court may make an order directing entry of a judgment, which implies that the court could just decide, nah, I'm not going to do it. But there's another case that elaborates on this exercise of discretion. Let's see if I found it. Yeah, okay, so here's my next assertion. While the entry of the judgment is discretionary with the trial court, the court should take care not to arbitrarily and capriciously exercise this discretion. There's another case, Libro v. Walls, which offers an example of when it is appropriate to deny entry of judgment. And so in this other case, the Supreme Court actually gives a judge an example as to when it's okay for them to refuse to enter a judgment even though somebody may be entitled to a judgment. So we have here, judgment for support of arrearages under the law is discretionary with the court. On a motion, the court may enter judgment for all or none of the delinquent payments. So they're citing two cases, Reed v. Reed and Folks v. Folks. They approved the district court's exercise of discretion not to enter judgment where the movement would not have been benefited by an uncollectible judgment, but the obliger would have been greatly prejudiced in the eyes of his superiors in the military. So this is what I was talking about in Part 83, only I wasn't using the law. I was just speaking out of my own internal sense of right and wrong. In Part 83, I stated that if my ex just could not plain pay, she couldn't afford to do it, she was going through some hardships, then I would never have sought the judgment anyway. And here is the Supreme Court stating that even if I had sought the judgment, the court could deny the request because it's uncollectible. The person can't pay. But this isn't a situation that's applicable to my case. And that's because my ex can pay. She makes 3 times as much. The amount is very low. And she just refuses to do so just out of spite. So we have a different situation here. We don't have an uncollectible judgment. We have a very collectible judgment, which, by the way, I do collect successfully. And whether or not my ex is going to be prejudiced doesn't matter, because in this particular situation, she can actually pay and it would actually be collectible. Moving on, so these are all new. These are things that I left out of my renewed motion. So it's good that I filed a renewed motion because now I'm addressing some of the district court's concerns. And had I proceeded with my previous motion, it's likely he would have just denied it anyway, saying the things that he'd stated in that previous order striking. So I'm addressing the judge's concerns. Sometimes I really wonder if he is actually ignorant about these things, because this is a guy who's been an attorney for a long time. And so I'm like, does he really not know these things? It's hard to tell. Sometimes I wonder if they just want to rule a certain way, and sometimes that requires the judge to kind of play dumb, like they don't know what's going on or that they don't understand a certain piece of law. And other times I'm like, well, he's a family judge, so maybe he really doesn't know how any of this works. I don't know. But to me, this isn't really that complicated. For an attorney, for a person who's not a lawyer, it did take me a long time to figure this out. But I'm trying to figure out how an attorney who's been practicing law for a long time, who went to law school, who passed the bar, how they wouldn't notice or how they wouldn't know how certain things that involve collection of judgments work, especially since, for the most part, a lot of attorneys need to actually, I guess they wouldn't need to collect the judgments. I guess they could just win the case and give it to their client and say, have fun. So, I mean, I might be wrong. Maybe a lot of attorneys don't bother doing this stuff. Maybe the attorneys out there win their cases and then just give the judgment to the client and say, hey, have fun collecting this. I don't know. It sounds odd to me. I would think that attorneys would want to help their client actually get paid and not just get a judgment and then just kind of dump them. But we'll see. I'm asserting, my final assertion here is that in the aforementioned case, the judgment would have been both uncollectible and would serve no purpose other than to prejudice the judgment debtor in my particular case. And then I'm asserting that she makes plenty of money. It's less than 2% of her income. She's intentionally refusing not to pay. Okay, so these two things I already cited, the statute for costs and the statute for interest and penalties. And then here we have the computation of interest, where, again, I already covered this in the previous motion. And then here we have the same conclusion as before. No, there's a little bit of a different conclusion here. I am appreciating the court's advice to seek counsel, the Self-Help Center, and to use the district attorney's child support enforcement position, and I am in fact seeking counsel when available and using the Self-Help Center extensively. However, I have elected to execute on the child support arrearages myself. My ex owes support and deliberately refuses to pay the amount. Refusing to reduce it to a judgment would embolden her to continue paying what she feels she should pay and not what she has been ordered to pay. I think I stated that. The point is that I'm trying to make here is that I addressed the judge's concerns. I didn't just sweep him aside. I didn't just ignore him. I went through his concerns one by one to let him know I knew what I was doing in this particular situation. And if not, he can respond to me and tell me how. I still don't know what I'm doing. Luckily, in this particular situation, he does end up giving me what I want. Okay, we got the declaration, which we've gone over before, but it's just me swearing under penalty of perjury that all the facts alleged in this document are true. And then the certificate of Rule 5 service, indicating that I personally dropped this off at my ex's attorney's law office. And then the motion opposition notice, which we've gone over before. Check the boxes and determine whether or not you have to pay a filing fee. In this particular situation, I don't have to pay a filing fee. List of exhibits, we have the judge's order striking request for submission, and I'm going to stop here because we already went over this order in part 83, and as my policy is on the My Docket series, I don't go over documents that I've already gone over. You can, however, go down in the description below, click on the link, download the document for yourself, take a look at the document, and if you have any questions, if I've missed anything, if anything looks odd to you, you can always post it down in the comments below, and I will answer your question. Request for submission. We've seen probably 30 of these by now. I have a video dedicated to the request for submission, so I'm not going to talk anymore about what the purpose of this piece of paper is. If you haven't seen that video, definitely take a look at it. I'm basically submitting this renewed motion to the court for consideration, and in this particular case, my ex did not file an opposition. So I gave her the opportunity to respond this time. I didn't just immediately submit it to the court, and she just didn't respond to it. She didn't feel like it. Oh, and if you want to learn more about what the time limit is for somebody to respond, please take a look at my video, Computation of Time. Here we have a notice of pending procedure. There's a local rule in the district that my court was lodged in, and it's WDFCR 34 that requires a litigant or their attorney to notify a family court if there are any other proceedings that are pending that may impact the case, I guess. I don't know, or that have to do with the parties, or that have to do with the issues, perhaps. I'll take a look. Oh, here it is. Here's a footnote. It says, parties and counsel shall notify the court of any pending or prior proceedings in which they have knowledge involving the parties, the children, or the subject matter. Okay, so that basically says it. If it's another case that involves myself and my ex, or our children, or the subject matter at issue, then we have to let the court know, this specific court know, as to what those proceedings are. So here I am letting the court know about some pending proceedings. We have the original writ petition in case 59554, and that's it. That's all I'm letting them know. And we've got a Rule 5 certificate of service indicating that I served this notice upon my ex's attorney. Here we have an order to set debtor's exam. So the judge gave me what I wanted. The judge ordered my ex, or the judge has reviewed my motion for supplementary proceeding in the aid of execution. The court notes that my ex has not filed a response. The court is recognizing in its next assertion that my ex is required to pay me $73.91 per month. In the next assertion, the court is recognizing that I claim my ex is in arrears for her child support. And my next assertion, the court is recognizing that I'm entitled under the law to examine my ex as a judgment debtor, and that I'm asking her to appear before a master or judge for such examination. And the court's granting it. He is saying he is hereby ordering my ex to appear before the discovery commissioner pursuant to the law concerning her property. She is required to bring all copies of her bank statements, paycheck stubs, tax returns from the period of January 1st, 2012 to now. She is ordered to bring with her copies of any documentation regarding any liens or other encumbrances. Next assertion is that we are ordered to coordinate setting the debtor's examination with the discovery commissioner directly. And that's what I do, because the next document filed is a notice to set. And here is my ex. By the way, guys, the notice to set is somewhat complicated, especially for non-attorneys. To know how this works, please watch my video, Notice to Set. I can't Well, I can explain these things over and over again, but it makes no. There's just if I've already done a video on it, it makes no point, or there is no point for me to just keep going into it over and over again. And a lot of these filings, they seem like they're simple, like one sheet pieces of paper, but there's a lot behind what they mean and what they do. Like with the request for submission, like with the notice of entry of order, and here we are at the notice to set. These are things that might look simple to you on their face, but there's a lot behind them. So definitely go and take a look at the video notice to set to learn how this process works. In the nutshell, I'm basically setting a date and time for myself and my ex's attorney to coordinate the date and time of the actual debtor's exam. So this isn't the date and time of the hearing that I'm setting. This is a date and time for us to meet and set the date and time for the hearing. It's confusing, and it has confused a lot of people before. There are people who have gotten one of these and then they think that's their court date, and it's just to save yourself the headache if you have to deal with this in your district. And then we got Rule 5 Certificate of Service, indicating I personally served the notice to set upon my ex's attorney. And here we have a proof of what? Why did I need to do this? Because I already did a Rule 5 Certificate of Service in the notice to set, but here I am filing a proof of personal service stating the same thing. Oh, okay. So this was my proof that I served this on the Discovery Commissioner. Okay, so in the previous certificate, I served the notice to set only upon my ex's attorney, and here I have realized, wait a minute, I forgot to serve the Discovery Commissioner. I need to let them know as well, and so I filed a proof of personal service, and here I am letting the court know that I also served the Commissioner. By the way, if you want to know what the Discovery Commissioner is and does, I think I have a video on the topic called Discovery Commissioners. Take a look at that video. If I don't have that video, instead it's going to fall under Hearing Masters because it's almost the exact same sort of approach and process. They're basically hired judges. Instead of being elected or appointed, they serve the judges who have been elected or appointed. You can kind of think of them as the employees of the judges, and they just sort of help them out with some of the I don't want to say boring, I guess some of the ubiquitous nitty-gritty nuts and bolts parts of the legal system that are just, there's just so much of that it would just take up all of the time of the judges. And so they kind of dump this stuff. I hate using those words. They have pejorative connotations. They assign this stuff to helpers. Think of them as helpers, people that are there to help them with their caseloads. Going into the aftermath, I have filed 1, 2, 3, 4, it looks like five documents. Yeah, 5 documents. They were all free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. I think that my ex's attorney would have probably not spent much time at all reviewing the request for submission, the notice of pending proceedings, the proof of personal service. So I'm going to put those each at 1 minute. So we're looking at 3 minutes so far. I suppose she might have spent 5 minutes with the notice to set just to sort of put it in her calendar so that she would know that she needed to pick up. She wouldn't even appear at the appointment setting location. She would probably just call in. So we're at 8 minutes so far. I doubt she cared to look at the renewed motion. She didn't even respond to it. It was mostly the same. So I guess that could just be 2 minutes. She could take us up. That would take us up to 10 minutes. 1, 2, 3, 8. That's 10 minutes. And then the order. The order she would have spent a little bit more time on. Maybe not so much reading as much as calling my ex and letting her know how this was all going to go down. So I think 20 minutes is safe. It might have been more, but I'm going to err on the side of her attorney trying to minimize it and say, you know what, this doesn't matter that much. In fact, just pay him the child support. If you really want to, you can go and disclose your assets at this location. So I'm going to say 20 minutes. I think that's a safe number. It is an order of the court, and it does have an impact on our client. So that takes us to 30 minutes at the rate of $250 an hour. That comes to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.